Audits, exposing corruption and standing for our rights. Chief Lawless, CPO Appeal Update. The 12th District's decision, including lies, corruption, and conspiracy.
Wildman and Audits, back at ya, with the opinion and decision from the 12th District Appellate Court. So, here we go, y'all. I originally recorded a video where I read the entire thing, and then I went back and gave you guys my opinions, pointing out certain flaws. This time, I'm just going to put the link in the description if you want to read the full 5-page decision. It's really not that long, y'all. Please check it out. It will give you some foundation for the rest of this video. And without further ado, I'm going to get into it. So this is the case of Chief Lawless against Wildman Audits, also known as Cody Henderson. So this is an appeal for a civil case arising out of Fayette County Common Pleas Court. Specifically, this case had to do with a civil protection order that the trial court granted in favor of Chief Lawless. And they're saying that they're protecting Chief Lawless because apparently Wildman made a threat to Chief Lawless, but Wildman was also at the same time charged with a criminal charge, and he's gotten that dismissed with prejudice. So I don't think that there's any viable threat that was actually made. At least the courts haven't found one. So anyways, here we go. Let's get into it. So I'm going to skim through the first page and get on to right here. So on May 21st, Henderson appeared in the Circleville Municipal Court for another case, which was also related to Chief Lawless, when two Pickaway County deputy officers approached Henderson to serve him with the petition and ex parte CPO. Police body camera footage submitted by Henderson shows Henderson repeatedly attempt to walk away from the officers as the papers were presented to him. Alright, let's get down to this. First and foremost, the body camera will be uploaded soon. And you all will see in the entire body camera footage, the officers never presented papers to Wildman Audits. They never did. All they did was try to read these papers. And I'm not a 3-year-old. I don't need anybody to read papers to me. That's not part of the procedure according to Ohio Civil Rule Procedure Rule 4.1. It doesn't mention having to read anything to anyone for service. So I'm not going to accept, a false procedure. I'm not going to allow you to change up the procedure and act like it's one thing when it's in fact another. To serve someone, all you got to do is walk up to them, identify them, and hand them the papers. That's all they had to do. I would have received them. But what actually happened, and you guys will see in the body camera footage as I'll upload a little short clip here, is as I'm in the courtroom, the two deputies walk into the courtroom and they say, "We got to read you something," which once again is not procedure. And I say, "No thanks, I'm good," meaning I'm not going to sit here and be your little child and let you read to me. And immediately, Officer Eitel of the Pickaway County Sheriff Department grabs me by my shoulders and slams me into the door, instantly violating my Fourth Amendment right and therefore converting him into a criminal because he violated my Fourth Amendment right without reasonable articulable suspicion of a crime being committed. Seeing as they were there to serve civil papers, me walking away from them was not A, obstructing business, and B, was not criminal. Now, they can, of course, send to the courts that I refuse the service, and they can pretend that they've already served me, and they can count it as being served, but the truth is they didn't attempt to present these to me. And furthermore, so it says the sheriff subsequently filed a return of service for the petition and CPO with the court. So what this was is the two deputies who violated my constitutional rights within the first 30 seconds of interaction filed an affidavit with the court affirming under oath that they had, quote unquote, personally handed these documents to me. Still to this day, I don't have these documents. I've never been personally handed these documents. And what we have here is we have a felony 3 perjury by Sgt Eitel and Deputy McCrabb of the Pickaway County Sheriff Department. And so if this court, 12th District, were to side with me, it would have huge legal implications for the state, including them having to investigate and potentially arrest some of their own officers, which would also verify and validate the federal lawsuit that will and is in the process of being pursued based upon the actions of the Pickaway County Sheriffs. So we have to understand that there's a lot of liability in this case, and ultimately the 12th District did nothing but protect the state's liability. And they lied in order to do so. So let's get back into this. So right here, let's go back to this. So it said that Henderson shows, police body camera footage submitted by Henderson shows Henderson trying to walk away as the papers are presented to him. I want you guys to remember this because the papers were never presented to me. They were attempted to be read. And I'm going to upload the full video here very soon, and you guys will be able to check that out. But you see this little number 1 right here. So this is referring to a footer at the bottom of the page. We'll go down here, and the footer says, the footage submitted to the court did not have audio. Okay, guys, this is total and utter bullshit. I've only had one copy of the video that I submitted to the court. It's the video that came directly from Pickaway County Sheriff Department. It has the original intact audio, and that was submitted to the trial court, which was then, that record was turned over to the appellate court. So this video that the appellate court reviewed, in which they state it does not have audio, definitely does have audio. And I'll have a video for you guys on that, because as soon as I read this decision, I physically and personally went up to the 12th District and I let them know that this isn't going to fly with me. And so I demanded to inspect the original USB flash drive with my laptop so that I could validate on camera that this video does indeed have audio, and that the 12th District has made an obvious error in refusing to review the record properly, pursuant and according to law. So anyways, yeah, I want you guys to look into that with the full video coming up soon. You'll get to see the audios in there, and I'll also upload the video coming up soon where I go to the 12th District and I force them to give me the record so I can inspect it. And I even have their little sheriff security guard admitting that she heard in the back that the video does have audio. So this right here that's highlighted at the bottom of the screen is a bold-faced lie. And I can't call it a mistake considering all the liability in this case, and considering that I've clearly argued this case skillfully on multiple levels of why it should be reversed. So here we have the 12th District just covering for the state and lying to do so. So we'll continue to go through this real quick. I'm just going to point out a couple things. So here's where they get into the legal analysis of the first assignment of error, where I claim that the trial court erred by acting with abuse of discretion, partiality, and prejudice. I should upload and show you guys at some point my motion for new trial and my appeal brief, because in both of those I clearly lay out a couple different arguments, and they didn't even address all those arguments in this decision, which is very interesting, because the most relevant and specific aspects of my arguments were completely overlooked, while these arguments were generalized and instead shot down. But anyways, we'll get into it. So they're saying that I declined to contract with the sheriff and refused service, which I do say that I declined to contract, but it's because these sheriffs violated my constitutional rights, and therefore any of their actions at the extension of the state in the U.S. Constitution are null and void, because they have lost the jurisdiction of the Constitution once they've violated their oath on the Constitution. Because the reason that cops have to take an oath on the Constitution is because their power is derived directly from the powers of the Constitution. So therefore, if they want to have jurisdiction, police officers or public officials, they have to follow within the rules of the Constitution. Otherwise, they lose the jurisdiction that Constitution gives them. So, when these officers came up to me, grabbed me by the shoulders, slammed me against the door within the first 20 seconds of interaction, without ever trying to hand me papers, they've lost the ability to serve me according to law from that point forward. So anything that's happened after that point is null and void according to law. And I also proved that in the criminal charges they charged me with, that I got dismissed with prejudice in relation to this situation. Anyways, I assert that I didn't have notice of the proceedings, which is true. And I also argue that the state has a vested interest in thwarting the $2.3 million lawsuit, Henderson versus Village of New Holland, against Chief Lawless in the Village of New Holland, which I think is very clear to anyone who looks at the circumstance of the total situation. The reason why the CPO was fought for and filed by Lawless and his attorneys is because they don't want me to give deposition to him in the $2.3 million lawsuit. Because if I'm able to depose of him and ask him questions in a private room, I'm going to quickly be able to demonstrate to the courts and the jury that my rights have been clearly violated and that they are liable. So they're trying to prevent that at any cost, including using gamesmanship and filing things like civil protection orders to prevent their client from being deposed of. And I want you guys to remember this very theory, because I have another case, which I haven't even told you guys about yet, in the Supreme Court of Ohio, where their attorneys did this exact same thing. And I've never even reached out to that guy. I've never said 2 words to their client, but yet they filed for a protective order to prevent me from deposing of their client. So this is all this is. It's gamesmanship. And it's not according to the rule of law. The Supreme Court has shot down gamesmanship many of times, where attorneys will try to get a one-up on each other by playing these kind of dirty tricks. Oh, my client needs protection from your client. Well, does your client actually need physical protection, or are you just trying to protect liability? Because those are 2 different things, and the court has no duty to protect your client's liability. Anyways, let's get back to it. So let's get down into the goodness of it. So it does say a CPO must be served in accordance with Civil Rule 4.1. And they talk about it being served in accordance with 4.1 capital B2A. The thing is in my arguments, in my appeal brief, and in my motion for new trial, what I argue is that if you look at Ohio Civil Rule 4.1 B2B, it specifically defines that, if B2A does not work, meaning that the person refuses it or something alternative happens, like the cops violate his rights and then lose the jurisdiction to be able to serve him, then they should serve it by certified mail. They should write down that it was refused, and they should give it back to the clerk, and the clerk will then serve it certified mail. Well, we have to ask ourselves, why would this part of the procedures, why would this rule be there if you're not allowed to refuse personal service, or if you're not allowed to deny service from someone who's violated your constitutional rights already, or some other extingent circumstance? And that's what's important to remember here, y'all. If they wouldn't have violated my constitutional rights within the first 20 seconds, it would be clear to say that I would be in the wrong here is in regards to the service. But the difference here is that they violated my constitutional rights immediately, and the court completely ignores and fails to address that, which I've argued in my briefs. Furthermore, they failed to address the argument of Civil Rule 4.1 B2B. All they do is list B2A, which I listed B2A as a means to then demonstrate that B2B is an alternative to that, and instead they just failed to address this argument altogether, which they do many times in this. So furthermore, let's keep going. Once again, guys, go read this whole thing. It's just, there's a lot of bullshit in it where they're saying things are one way and it's just not true, and I'm not going to go through and read every word. So, in this case here, B. dry cis, it says that where the evidence demonstrates that a party has deliberately avoided service of process, that party should be deemed to be constructively served at the time that he began evading service of process. So here's something important to note in this case. When the officers first walked up to me and said, "We got to read you something," I wasn't evading service of process at that point. I didn't know if they were reading me a child's book. I didn't know if they were reading me a magazine. I didn't know if they were reading me their own personal thoughts out of their diary. All they said is, "We got to read you something." So I wasn't evading service. I was evading being read to like a 3-year-old, because I'm under no obligation to be read to like a 3-year-old. If you want to serve me, you got to personally hand me these documents. And so absent of that, I have no reason to do business with you when I've not committed any crimes. And so the thing is that B. dry cis, this case law wouldn't even apply, because in this case at hand, the service was made via certified mail, which means the person's constitutional rights weren't violated by those who attempted to serve him. He wasn't physically assaulted by the people who swore in an affidavit that they did something proper. Well, it's kind of hard to swear in an affidavit that you did something proper and be credible after you just violated someone's constitutional rights after you've taken an oath to protect their constitutional rights. It kind of brings into credibility into the whole thing, which I challenged in this through and through, is that these officers aren't credible, and that they need to be charged with perjury. And so it's easy to see why the court would deny these arguments, because they don't want to charge their own officers with perjury. They don't want that to get to the media. They don't want that to get out to the people. So I just want you guys to keep this in mind as you're reading this. Their vested interest to minimize constitutional rights and to protect the state from liability. So let's keep going. As a result, we concluded that the trial court did not use its discretion in determining that Henderson was served with the petition and CPO, and that his actions were a blatant attempt to avoid service of process. But they failed to address the constitutional rights violations of those who were serving. Interesting why they wouldn't even address that argument. You think that would be a huge deal. You would think that all these people taking an oath on this Constitution, you would think that it's like the foundation of the entire legal system and the supreme law of the land or something. And it gets completely ignored here in the state of Ohio, apparently. We also find that even if we were to assume the trial judge improperly considered Henderson's phone call to the court, okay, we don't have to assume that. The judge did improperly consider that phone call, because the phone call wasn't made to him, so he didn't have personal knowledge of it. There was no affidavit about the phone call, so there's no evidence to support it. Neither party, me nor Lawless, submitted any evidence about this alleged phone call, meaning that the court itself, aka Judge Bender, submitted his own evidence against me for no reason. And to put this into perspective, a judge is a neutral referee in the game. And so it would be like a referee catching the ball and running it to the end zone for a team. And we all know that the referee can't play football. The referee can't play the sport. He's ruling on it. And that's exactly the same in fundamental law and common law here in the United States, English common law, pretty much anywhere you go. It would be entirely improper for a judge to be able to enter evidence against you, for the judge to practice law against either party. Because how can he be a neutral decider of what is true and what is right if he's playing the field? He can't. So the judge was obviously acted with impropriety there, and that's actually a violation of law. So anyways, the 12th District goes on to say that when determining if Henderson had the notice of proceedings against him, such error would be harmless because Henderson has judicially admitted in his brief to having made the call. So they're stating that just because I later admitted to making the call, which, yes, I would address the call that the judge put in his order that he denied the motion for new trial with. So this is the timeline of events. I filed the motion for new trial because they had a trial without me, because I had no notice. Okay, let me back it up. I happened to call the court the day of the hearing by happenstance. As I argued in my oral argument, if you guys saw that, I had an attorney in a different county, and all he told me is, you have something in the Fayette County Common Pleas Court, you need to call them and get that handled. That's all I knew. And so I called the court like a week later after I'd handled some stuff, and it happened to be the day of the hearing. I have that whole conversation on recording, and I will upload that as well if you guys want to see it. So I have all this stuff documented. And during that call, I was actually really surprised that the hearing was that day, and I was actually really upset that they didn't inform me about it. And I immediately went up there, got the public records, and filed a motion for new trial the very next day. In that motion for new trial, yes, of course, I did admit to having made the call, because what I did is I denied that the call was based on me admitting having service, because what Judge Bender said is that I had called to say that I was running late. In the video, you guys can watch it, I didn't call to say I was running late. I called to get the court date because I wasn't aware and I wasn't given a notice. So what the 12th District here is doing is they're making a decision based on the evidence, the hearsay evidence that isn't proper, that was admitted by Judge Bender. And they're assuming that what Judge Bender admitted against me is true, even though I've argued against it. And they're retrospectively applying something. So think about this. So I filed a motion for new trial. Judge Bender gives his erroneous order, which should be reversed. Then, let me back that up. No, that's correct. Yeah, I file a motion for new trial. Judge Bender gives his erroneous order. Then I file an appeal on it. And then in the appellate brief, I admit that he made the erroneous order and that I did not call to say I was running late. I called to find out when the hearing was because I had not been given notice. And so I argued all that in my brief. And instead of the 12th District acknowledging the evidence that was before them in my affidavit, they instead decided to make a bald assertion with no evidence to support it that states, such a call can only be interpreted as Henderson knowing of the hearing that day but failing to appear and defend against the issuance of the CPO. Now, tell me how just simply making a phone call and saying that you don't know when the hearing is and you're calling to get the date of the hearing and the time, how is that evidence that can only be interpreted? Because evidence that can only be interpreted means beyond a reasonable doubt, meaning there's no other way that this could have possibly happened. And so here we have the 12th District lying again. Clearly lying. So we're going to go into this because I've filed a motion for reconsideration that's over 20 pages. I'm going to go through with you guys because I'm not going to let this happen to me. I'm going to keep fighting this because we can obviously see here that the 12th District shot down my appeal and that they're backing their buddies in blue. And they basically say right here that it's not the duty of an appellate court to search the record for evidence to support an appellant's argument. So they're basically saying that yeah, there's evidence to support the appellant's argument in here, but we're not even going to look for it. And that's clear in the fact that they didn't even listen to the audio that was attached to the video. That clearly shows that these officers didn't try to personally hand me anything. All they did was try to read to me. So anyways, on the second assignment of error, they say that it's moot because they resolved the first assignment of error against my favor, which is kind of crazy because you think in an appeal, let's say a trial court makes multiple errors, and let's say you list them as multiple separate errors. You would think that each of those errors would have to be addressed separately. Just because the appellate court decides there wasn't an error in the first one doesn't mean there was not an error in the second one. So, that's a whole nother issue I have with the appellate procedure. Apparently that is a rule that they can basically deny your appeal for one thing and then apply it to every other thing. And so that's Ohio Appeal Rules of Appellate Procedure 12A1C. The other two judges concurred. So what does this mean? Well, this means that they've decided to affirm and protect the state, affirm what the state has said, affirm Judge Bender's erroneous order where he entered his own evidence against me. That means that they are conspiring against the Constitution. They're conspiring against the fundamental basis of common law in this country, where judges cannot enter evidence against you or practice law against you. And furthermore, it means that Wildman Audits now filed a motion for reconsideration. And if you guys are wondering, why would I file a motion for reconsideration? This is why. So I have to exhaust remedies before taking it up to a higher court. So I have to file a motion for reconsideration before I can file this and appeal the 12th District's decision in the federal court. And so that's ultimately the pathway that I'm leading towards, is I can hereby file the appeal of this appeal in the Ohio Supreme Court, where I have other cases currently, or in the federal court, where I have another case currently. And I think because the Lawless case is in the federal court, it's going to be better received by the federal court, who has some insider knowledge of our interactions and our history. So anyways, I'm sorry for the long time that it's been since I've updated and uploaded this video. I would love for you guys to stay tuned. I'm going to have more videos coming up about me going to the 12th District and addressing them about that video, obviously having audio. And I'm going to be going through my 20-page motion for reconsideration, their attorney's response to that, which was really short and weak, and then my reply to that. Furthermore, I've got other cases going on that I'm going to start trying to get you guys some foundational knowledge about, and then informing you guys on. Don't want to share too much right here right now, but there's a lot in the works, and Wildman's a busy man out here. So I'm going to keep litigating these cases, standing for our rights, and I recommend you all to do the same. Remember, keep your cameras on you, always film when you're interacting with public employees, and as always, stand for your constitutional rights. Please like, comment, share, subscribe. Give me some suggestions, you guys. If you guys want me to go in depth with more legal jargon, I can definitely do that. I just try to keep it simple for the viewers out there. Additionally, I have a lot of other legal documents that I can review for you guys that I've filed in different cases. If that's the kind of content you guys want, let me know. Additionally, in regards to this one situation with this CPO, I am going to be uploading the original body camera footage, and it's pretty graphic. They triggered my PTSD severely that day because they were violating my constitutional rights. I knew it. I made them aware of it, and they had no concern or care for it. So I will be uploading that as well. I will be uploading the phone call that I have with the trial court, where I inform them that I'm calling to ask when my hearing is. And then also, I'm going to upload the video of me going up to the 12th District and demanding to inspect their public records, which you guys will love, because the first response I got was, "We don't have public records here." And Wildman is not going to accept that answer. So stay tuned, like, comment, share, subscribe. Much love to y'all out there. Stand up for your rights and keep exposing these people. Let's do it.
Thanks for checking out this update from Wildman Audits. The 12th District shot me down, but I'm not done yet. Stay tuned to watch me appeal this up to the highest courts in the land as I stand for constitutional rights. Comment, like, subscribe, and share. Wildman out.